Hello, 13th jurors. Welcome back. Welcome back. Welcome back. Welcome back. Are we rested? Are we full? Are our bellies full? Did we get a nice break? I did. I went out to the beach for an hour and then came back in and started digging. Before we get going, fix my microphone. Before we get going, first in tailgate when we came back, Portland Trailblazers TV, congratulations. I still haven't learned the whole video thing. We're going to get there. But today we got the old school graphic. So congratulations, Portland Trailblazers TV. First back in the chat. Congratulations. Grab your throne. Miss BZ, congratulations to you. You were second in the tailgate. You get the science stool. And Mammy P, congratulations. You were first. No, you weren't. You were third. You were third. But you do get the most comfortable of all the chairs. It's not the fanciest, but it's the most comfortable. So congratulations to y'all. I hear beach police sirens. They're getting somebody out there, and I'm pretty sure I know who it is. Okay, so friends. So since we were talking about, let me exit out of this. I got 100 things open. Since we were talking about our friend who likes to laugh with Melly, I pulled some court records. So we looked at her screenshot, or we saw her screenshot this morning when we looked the attorney Raven Liberty, his attorney that he giggles with. So we saw her mugshot, and it was a beautiful mugshot. She looks lovely. So that was the only one that they had on the website that we happened to stumble across. So I pulled her information from, and this is just Miami. That's the only one I had time for. So now these are old charges. Well, one of them's last year, but the rest of them are older. So this one was in 2007. She was arrested for or charged with disorderly conduct at an establishment, resisting arrest without violence, and trespassing on property after being warned. Okay, so she resisted arrest, but it was without violence. So that's fine. No, this is not doxing her. This is all public record. All you have to do is pull it up. All public record is just that. It's public record. So let's see. And then stairs. I always think I'm going to do those wrong. So that was one of them. And then the first one was even older than that. This one was 2001. And this one was trespass. That was St. Patrick's Day. Look, who hasn't trespassed on St. Patrick's Day? Let's be honest. And let's see. And then, of course, the mugshot that we saw was from last year, August 26th. And that one was battery. So that's it. That was her stuff. But fun times. All right, so I mean, whatever. I'll be honest. I care more about her disrespecting the families by giggling than I do about any of that. So, you know, it is what it is. Um, and that's just my personal opinion, which I'm entitled to. Let's see. It Jill C, it did not say anything about a doggy door. I think we're leaving that for Miss Arias. But yeah, it's nothing too bad. It's just, I mean, and you know, some of this stuff is old. Like I said, one of them's 2007, one of them's 2001, and one of them's St. Patrick's Day, which really doesn't even count anyway. Who hasn't broke a law on St. Patrick's Day? This isn't as bad as the two attorneys that he had. The ones from Louisiana that he wanted to represent him, and so he filed the papers to get so that they could represent him, even though they're Louisiana and he's Florida and all that. And then they ended up with federal charges. Oh, goodness gracious. Let's see. There is, what do we have? We have like 7 minutes until we're supposed to start. I have not heard anything else about I was looking for notifications. I have not heard anything else yet about if the juror is or is not back. So we'll have to find out as they start back. Let me go ahead and get our screen ready. Okay, we're ready. We're ready. I went out to the beach on break. I'm going to refresh this, make sure I'm not missing any updates from the courthouse. Nope, not a one. I went out to the beach on my break. And just now realized I'm still in my beach wear, but that's okay. Doesn't matter. Y'all love me anyway. JT is feeling better today. I should have spent more time getting prepped instead of researching arrest records so that I have all this. Okay, now I'm set up. Now we're good. I went out to the beach for an hour and I took Lucy out. She got to go out and go see her little friends. So the office that's downstairs, when I take her out, there's like a little area out front of our condos where it's like a little puppy pad, like that's where you go out there from like right outside the front door or whatever. It's like a little area. So making sure it wasn't coming back. So I take her out. And when she comes back, she knows that when she goes in potties and she comes back in, then she can, as long as the office is open, as long as there's somebody in the office, there's two ladies that work at the office, depending on what day it is. And so she knows that when we come back in, she can go in the office and the ladies love her. So whichever one is there, she'll get a treat. So she got to go down there and see her friend and her friends in the office and sniff everybody and say hello. And she got all kinds of attention because, the vacationers who come and stay here, you're not allowed to bring dogs when you stay here. But if you're an owner and you live here, then you can have dogs because we have to like give the shot records and stuff. So there's a few of us that live here that have dogs, but the vacationers, when they come, they all miss their animals, so they all see Lucy and they all get so excited and, they're like, oh my gosh, I miss my dog. I want to hug her. So she gets all kinds of attention when we go out and she loves it. She loves attention. She's a funny little thing, but it wore her out. Between that and being out in the sun and stuff, it wore her out. So now she's over there like passed out on the goat pillow. I love that little baby. We still have some people filing in. There are no tweets yet on anything going on in the courtroom. I was just looking, and I guess Bryson is not. He said to follow somebody else because he's not going to be in there now, I guess. Let's see. Oh, this is funny. Free Melly is trending on Twitter. It says it's trending in rap on Twitter. Oh, let's see. Bryson said he said he's doing a Q&A on TikTok at some point tonight. But yeah, he said to follow Terry D. Austin, who is in the courtroom, who is now in the courtroom covering the Melly trial. So I put on my notifications for her too. Let me pull, but I don't know why he's not anymore. But she hasn't posted, or she hasn't tweeted anything since. She has one tweet. But it's like recent. But other than that, she's not a big tweeter apparently. But hopefully she will keep it. She has one from June 14th and one from June 9th. And nothing since then. So hopefully she will start to pick up her tweet habit, so that we can all be nosy and find out what's going on in the courtroom. Alrighty, let's see. I don't know that I would want to go sit in a juror's box either after being that sick. Speaking of food poisoning, it's Taco Tuesday, everyone. That's a great, great intro to Taco Tuesday. Hi, Lindsay Hendricks. I remember Bryson tweeted that, and I said it on air one time, but I don't think I made a note of it, and I don't remember. I don't remember what it was, but I would have to go back and look. But I know that he did tweet it at some point. Dang. Forgot my water. Yeah, the juror, he, I don't remember. The juror offered to come in this afternoon and said that it'd be there at 1:30. So I've got the screen on over here. They ain't back yet, but hopefully soon. Hopefully soon. Because I'm ready to get the show on the road. I woke up at 5:30 this morning so that I could take Lucy out and get all my stuff done before we start. And then I saw that and I'm like, dang, y'all, I could have been sleeping. Could have slept in. Do you know how many more hours of beauty rest I could have gotten? Let's see. Yes. However, they did let the attorneys decide what they wanted to do, and I guess they said that they wanted to wait. So who knows? Who knows? Hopefully they're there. Let's see. I don't know. Look, as somebody who's spent a lot of time in an ER in a hospital, you can't predict that very much. Because even when they tell you they're about to discharge you, that could mean that you're going to be done in an hour, or it can mean you're going to be done in 4 days. Like, about to discharge you is like not an actual time estimate. So I don't know. Yes, correct, Jill C. Never a wasted day. We got to spend time together. Got to hang out, look up stuff. Oh, thank you. I will go. I'm going to go to the post office box as soon as we finish court today. I'm going to go check it. Yay. Hello, hello. Welcome, welcome. If the juror doesn't feel better, then I guess that if the juror hasn't made it back, then they'll ask what they want to do. I don't know how many alternates they have. I don't think I've heard that. And if I have heard it, I didn't retain the information. But yeah, same. Look, I basically lived in a hospital for 6 months, and there was anytime I would get to the point where I was finally able to get out, like they would let me out, then it was like, depending on who's doing what and what's going on. I mean, if it could be, the paper, most of it was like waiting on paperwork, waiting on whatever. Man.
Everything was just, I guess, issued dehydration or something along those lines, but I'm told she will be here. You hear me? One thing though I need to bring to your attention is when we broke this morning, one of our jurors, as Gary was escorting the jurors out, he was approached and one of the jurors had asked him a question. Gary, go ahead. You want to tell us exactly what was said?
She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
So now, I don't know what you want me to do about that, but that's the question was posed.
Judge, we need to have her name on the record and find out how she would have any knowledge of that, because that was never stated in front of them.
I think it was.
It was.
I think there was it was done on the record by Mr. Howard the other day. Is Mr. Howard here? No?
No, he's not.
Oh, I apologize. I thought we were all here.
He's coming right now, Joe.
Mr. Howard, I'm sorry.
Oh, no problem with it. I heard it all inside the media room. So, no apology necessary. Thank you. Apologize for not being present.
No, it's my fault. I thought Gary walked in, but what he was advising me and I to the attorneys was that there was a comment by one of the jurors. Did you hear that?
Yes.
So I don't know exactly what you want me to do. Who the juror was?
That was Miss Manuel.
Miss Manuel. So one of the things that is, my recollection, and I could be wrong, is different than yours, Ms. Bradley. My recollection is that there was a motion for mistrial that was made out loud, and Mr. Howard came sidebar. But the jurors have been instructed not to read anything about the case. So I don't know if there's something in the newspaper about that. That's a different story, but I don't know what you want me to do, if anything. I bring it to your attention, any real interaction that Gary has with them, something that may seem inappropriate, we always bring it up and let you know.
And should I assume that for future reference, you'd rather I make those motions outside the presence of the jury?
Just come silent.
Okay.
But that was my recollection. I thought you, at one point, I don't know which, there was two motions for mistrial. I don't know at which point, but I believe at least one point you stood up and said, I have a motion for mistrial.
No, actually, there was a question asked. I said objection, move for mistrial, and you called the sidebar and asked me to hold it until the end. And then at the end, after the jury left, Mr. Allison and I articulated motions for mistrial on an independent basis. And that's how it trended. That's how it went down.
But it was announced in open court, correct?
I said objection, move for mistrial. You called
That's
the
my
side-
recollection.
I remember putting sidebar and there being that being sidebar. I don't recall it being said in open court.
It was said in
I
open
thought it was
court.
said in open court.
It's a fact that I said it.
So again.
So it was
I don't
after
know
the
what
Instagram stuff.
you want me to do, if anything, and, the jurors, is that juror here, by the way?
She's in the reception area.
So, anyway, I'll leave it to your discretion. It was announced in open court, there was a motion for mistrial. Gary obviously didn't answer the question. And, what did you respond, Gary?
I told her I didn't know anything about that. And then she asked me, weren't you there? I said, I don't remember that.
Anyway, that's where we're at. So, you think it over. Let me know if there's any inquiry you want me to make, Madam.
Yeah, I think you need to, the state's position would be that she needs to be brought in. Your Honor needs to inquire if she's seen anything in the media or any coverage of that, because that was discussed online, is my understanding.
What do you think, counsel?
Oh, to the extent that the court's inquiry of this jury is because of the state's faulty recollection that I didn't say move for mistrial in front of the jury. I know that not to be the case. I did say objection, move for mistrial. You then called a sidebar, and the only thing you said was, please reserve that to later.
That's my recollection.
Yeah, that's what.
Again, is that what you're concerned about, or is it concerned about just because it was said that you think I ought to inquire?
Your Honor, I think that exact defense is sterile. If we go forward, and if they're going to waive any inquiry of this witness, if she's been looking at any of the other items or anything online, the defense brought to Your Honor's attention earlier. Because if they thought was laboring under the impression that there was some sort of cessation of trial and then started looking at media and news reports because they thought their jury service was over, that would be a problem.
Better to have more information than less, so we have no objection to that being the procedure that we employ.
So you want me to bring her in, indicate to her that I was advised by our bailiff, Gary, that you asked him a motion for mistrial and what had happened, and just ask her, how is it that you're concerned about that, or where did you hear about it, and just find out what information she's got and about it and where she heard it from. Is that the end of the inquiry?
I would ask that you inquire from her if she conveyed any of that to any of the other jurors.
Anything else?
Unless the court wants to say, unfortunately, I denied it.
So we're gonna ask, what she heard, where she learned it from.
If she did any outside research afterwards,
And if she inquired or asked any of the other jurors concerning the topic.
Okay. Yeah, he definitely did. It was right after she read the Instagram stuff out loud.
Anything else that you want me to ask, counsel?
no,
Anything else?
Nothing, sir.
All right. You do me a favor?
We went together.
So, if you'll remember this morning when we played the mistrial clips before we got started, if you'll remember, it was when she
I don't like it either.
read the Instagram stuff out loud when they told her not to, and he let her finish the whole Instagram thing and then said, objection, move for mistrial. So now one of the jurors has asked the bailiff
Just for
an update on the mistrial, and so they want to question her to find out if that's where she heard it, or if she heard it somewhere else, or if she's done any outside research or anything like that. The jurors were in the courtroom when he said that objection, motion for mistrial. But they were not in there during the discussion afterwards. Like for that whole thing where, remember when the fella got mad and like threw his notebook and stuff on the, they weren't there for any of that, but they were there when he said move to mistrial or motion for mistrial. But we watched that clip this morning, so I remember very fresh in my mind. And they were definitely in there. They just weren't in there for like the whole argument phase of it. Ah, this is a mess.
Thank you. Thank you. Ms. Manuel's coming in, counsel. Ms. Manuel's going to come in now.
Okay.
Thank you.
All right, so now we're going to hear from the juror. I'm going to grab her dozen eggs and go home. Yep.
Juror Zachary?
I'm not sure how many alternates they have.
Hey, Ms. Manuel, thanks for coming back in. Let the record reflect the approach of the defendant, his counsel, the assistant state attorneys, as well as one of our jurors, Ms. Manuel. Counsel, please be seated. Ms. Manuel, please be seated. Ms. Manuel, why I brought in is my bailiff indicated to me that when you weren't able to start this morning, that he was escorting the jurors out, and you approached him and asked him about what happened with the mistrial or something to this effect. Is that right? So that's a yes. All right. So I guess my concern is what you may have heard about this alleged mistrial and where you heard it.
The last day I was here, and the defense attorney jumped up and said mistrial.
Okay. So that's where you heard it from?
Yes.
Anything other than that?
No.
Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No.
Anything on the news, any news media
No.
about the mistrial? No. And last but not least, did you speak with any of the other jurors about the motion for mistrial?
No, when Gary came in and asked us this morning, do we have any issues, any questions? And I didn't want to ask him in front of everybody, so I waited till we got in the hall and I put him to the side and asked him that. If he asked me, we have any concern.
Okay. All right. Okay, that's what we're trying to clear up and find out. Because there's an admonition that I say every time we break, don't discuss the case, don't form any opinion about
Oh,
the
it was
case.
said in here.
That's what we're trying to find out.
Okay.
Thank you, man. Appreciate it. Thank you. Let the record reflect the juror stepped out. Counsel remain will defend. Anything you wish me to do regarding this issue with this manual?
No, sir.
So we otherwise ready to proceed?
Yes.
Juror shows up, yes.
I think, are they all here?
As far as I know, yes.
Okay, so see if they're all here. If they're all here, we'll start. Yeah, he did say we're short 2 or 3. 3. But they're here now? All right, they're all here now.
This part.
Hi, hi, hi. Look, she's looking up right now where we tweeted her mugshot. She's mad. It's interesting that she asked about the mistrial, though, because I don't know. I'm trying to think about like being in her position. I don't think I would just ask the bailiff about. I mean, I know I wouldn't, but I'm trying to understand. I don't know.
You all ready?
Go.
Okay, council, I'll bring it in, is that all right?
Yes, sir.
All right, let's bring the jury in.
This is exactly how I feel right now. I don't know who she's passing the note to.
Thanks, Tom.
I mean, look, they're trying this in Broward County too. It's going to be real hard for them not to hear something about this.
Jury entering.
Yep, now we're moving right along.
Steve, you see it? Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys, and his ladies and gentlemen of the jury. Ladies and gentlemen, sorry for the late start. Hopefully everybody's all right. We appreciate your patience. We also appreciate the fact that you're all here. We thank you. But we're ready to begin again. When we left off last week, the state was still on this case in chief. Madam, who's your next witness?
Susan Johnson of T-Mobile.
Susan Johnson, please.
Oh, T-Mobile. Oh, this is the phone stuff. Oh, Heather, honey, you have been a member with us for 1 month. Happy 1 month anniversary. 1 month anniversary. Oh, this is the y'all. This is T-Mobile.
Good afternoon. Are you Susan Johnson?
Yes, sir.
Welcome.
Thank you.
What I'd like to do is raise your right hand for us.
On.
Do solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth.
I do.
Please state your full legal name for the record.
Susan Johnson,
Please spell your first and last name for the court reporter.
SUSAN, JOHNSON.
Please have a seat.
Thank you.
Ms. Johnson, that microphone in front of you will adjust up or down, but not back and forth. Okay?
Thank
Are you
you.
ready to proceed, ma'am?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Ms. Johnson. How are you today?
Good, thank you.
Could you please introduce yourself to the ladies and gentlemen of the jury and tell them where you work?
Sure. My name is Susan Johnson, and I work for T-Mobile.
How long have you worked for T-Mobile?
A total of 26 years.
And what do you do for T-Mobile?
I am a manager within the legal emergency response unit.
Prior to working for T-Mobile, did you work for any other telecommunications companies?
Yes, I did.
And what were those?
AT&T Wireless,
And how long did you work for AT&T?
5 years.
How long in total have you worked in the telecommunications industry?
31 years.
So you indicated you were part of the manager of the emergency response,
Legal emergency response.
and what does that mean?
That means that we respond to subpoenas and other legal demands from various agencies across the United States.
And when you say a legal demand, what would you mean by that?
Subpoena or court order, search warrant.
In terms of the records when you work with them, how often do you work with them?
No mistrial.
every day.
What do you do with the records?
So we're able to retrieve the information from our secure computer database,
Thank you.
and then send the response back to the agency that's requesting.
And I know this might sound silly, but what type of company is T-Mobile?
We're a wireless telephone carrier.
And is T-Mobile the parent company of any other wireless carriers?
We did acquire Sprint.
How long has T-Mobile been the parent company for Sprint?
April 1st, 2020 is when we acquired them.
In terms of the information that is kept by T-Mobile, do you keep phone call records?
Yes,
What would you call those?
call detail records.
Do you keep information regarding the networks?
Yes,
Do you keep information regarding subscribers?
yes.
What type of information is kept in a call detail record?
So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone.
Does T-Mobile keep that information as to when data is used?
Yes,
Will a data phone call or video call show up in call detail records?
no,
Does the information show for who is being called?
yes, it will show the transaction of the outbound or inbound phone call on the call detail records.
Does T-Mobile keep the cell site information for the call that the outgoing non-T-Mobile subscriber?
No.
What's the purpose of collecting this information at T-Mobile?
Billing purposes.
Is there any consideration as to the health and optimization of the network?
So we keep what is known as timing advance records, which is solely for engineering purposes, so that they are able to check up on the network, yes.
When a phone call is made from a cellular device or handset, can you describe from the network perspective what happens?
Sure. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street. However, the one down the street might be the stronger signal and would pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records. At that point, it's then transferred to a landline company, and it's the landline company that actually delivers the call.
So you mentioned true call data. What is that?
So true call data is for the network. It will show where the phone is connected to when it's not in use, as long as it's turned on.
Does Sprint also have a similar type of data?
Yes,
What is per call measurement data?
correct,
Is that the same for true call, for the Sprint analogy?
correct. That's Sprint's term.
In terms of subscriber information, what types of subscriber information is kept?
So the subscriber information, we have two types. One would be a prepay, and then the other would be a monthly account.
So the prepay, what type of information could you have?
So prepay, a customer is not required to provide their information, but they could provide a name, address, and date of birth.
On the postpaid or the billed type, what type of information do you have?
So we would have the name, the address, date of birth, social security number, and we actually do a credit check on that individual.
In terms of the individual using the specific phones or handsets, can you testify to that?
No.
How many times have you testified in court before?
Over 1,000 times.
Were you, as the record custodian for T-Mobile, provided legal process, I'm gonna go through them one by one. Under reference tracking number for T-Mobile, 214-6318, for two phone numbers of 305-922-9533 and 954-376-9158.
Yes,
As the T-Mobile record custodian under tracking number 219-2645, were you provided records and requests and legal process for 3 phone numbers, 561-720-3210,
I saw that.
772-713-9807, and 954-376-9158.
Yes,
As the records custodian for T-Mobile under T-Mobile tracking ID 208-1851, where you submitted requests for phone number 954-248-9081.
yes,
For T-Mobile tracking number 217-2715, for phone number 954-376-9158, where you provided a legal process to obtain the records for that issue.
yes,
Were you also under tracking number 205-8127, asked to provide for legal process phone number records for 772-713-9807?
yes,
Was Sprint at the time, part of T-Mobile, under the phone numbers for 772-713-2341 and 954-371-7895 under Sprint tracking number 2018-221418, provided legal process and requested to provide records.
yes,
Was Sprint under Sprint case number 2019-15821, asked to provide records with regards to phone number 225-529-5054.
yes,
Prior to coming into court today, did you have the opportunity to review the records that were provided?
yes, I did.
Are these records made at or about the time they are created by a person with knowledge?
Yes,
Are they kept in the regular course of business of Sprint and T-Mobile?
yes, they are.
Okay. Is it in the regular practice to keep such records?
Yes,
You're at this time approaching with what's been labeled as states 000 for identification purposes and previously shown to defense. Ms. Johnson, do you recognize this USB?
yes, I do.
How do you recognize it?
My initials and today's date are on the USB.
And does those USB fairly and accurately represent the records that were provided by T-Mobile in response to the tracking numbers that we just discussed, as well as to Sprint and the tracking numbers and case numbers they just provided?
Yes,
Here at this time, the state would offer states 000 as state 63.
Any objection?
Yes, Judge. Objection? Relevance?
Sure, why don't you come sidebar?
Sidebar. Objection for relevance is actually kind of funny because this is probably one of the most relevant things that we've heard so far. This is going to be interesting. This is one of the things that I've been really interested to hear because they say that the cell phone evidence puts him, obviously we see him get in the car from the video evidence. They said the cell phone evidence keeps him there and that he has a phone before and after the murders happen. So that's what they say. So I want to hear the actual data so that I know what, I'm not just going by what they say. I like to hear it myself so I can make a decision. Interesting. Let's see. No, they sidebar for everything. What if like we don't know what they're really up to? What if they're like every time they do a sidebar up there, like they take a shot or something, and we just don't know, and that's why they're doing so many, and that's why things have gone completely off the rails. It's a possibility. What else could they be doing? There aren't that many sidebars in the world that we need. If this were night court or like if this were like an evening trial and not like starting at the crack of dawn, that would be a fun game. Or like if you're watching on like the replay crew, that could be a fun game. For every sidebar, take a drink. Don't do that. Don't do that, Mrs. Trout. Don't do that. Let's see. Literally a sidebar. Literally. Yes. Or like if you want to make it like a healthy thing for every sidebar, run in place while they're sidebarring. You know, get some calories in. If you're supposed to be working for every sidebar, do your actual work instead of hanging out with us. We could make this like work for us, all these sidebars. You know, we could really make this work. Oh my gosh, what if they are, oops, where'd it go? What if they are telling each other jokes? What if they're up there and like that's like their sidebar and they're like, oh, guess what I heard? Like a rapper and a judge and an attorney walk into a bar or something. That'd be really funny. Let's see. Squats, 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 squats. Every time they're on a sidebar. See? Or with espresso, you would be wide awake. Instead of being exhausted when this ends, you would be wide awake.
Thank you. So, objection overruled, it will be admitted. What's the next number?
63.
63 and over.
Permission to publish?
You may.
I'm sorry, I didn't catch you.
63.
So I'm going to start with the Sprint records. What are we looking at in this particular file, 2018-221418-6155597?
This would be the subscriber information.
And in terms of looking at this particular one, I'm going to zoom in. What is the billing name for this?
Chris Thomas.
And going to the second one, what is the billing name on this one?
The first name is Dontavius. Last name is Withers, Withers.
At the top of this screen capture, there's a BAN number. Do you know what that means?
Yes,
What is that?
that would be the account number.
Does that correlate with the other data that's been provided?
Yes,
Going to now the same Word document file name. What are we looking at in this Sprint document?
this is also subscriber information.
So you had mentioned that billing account number, that BAN number.
Correct.
If you can touch the screen in front of you, you can write on it and it will show up on the screen for the jurors. So if you could point out where the billing account number is here. Okay. And then what is the phone number that was being used by this account, or the subject number?
772-713-2341.
And is this again for that Chris Thomas billing account?
Yes.
Okay. Scrolling down to the next billing account number. Is this the other account that we just looked at the subscriber information on for Dontavius Withers?
Yes.
And what is the phone number that's associated with this particular account?
954-371-7895.
Going on to 2019-158-210-6566861. for the phone number in question on this particular record. Is that labeled right here?
Yes,
And what phone number is that?
225-529-5054.
Chris Thomas is juvie. And Dontavius Withers is one of the other ones that was
I'm
at the
looking
studio
at
with them.
Microsoft Excel viewer. Can you explain to the ladies and gentlemen of the jury what we're looking at here?
These are the call detail records with cell site information for Sprint.
Going over to the T-Mobile records. Just for demonstrative and illustrative purposes, when you are looking, this particular one called Timing Advance LTE and UMTS _TN 772-713-9807. Then it has another underscore IMSI. What is an IMSI?
That stands for International Mobile Subscriber Identity Number, which is the number that's associated with the SIM card found in the back of the phone.
And the first, the 772-713-9807. What is that?
That would be the phone number.
Are all of these records provided by T-Mobile?
Yes,
In terms of completion codes, is that something that is reflected in these records?
yes.
What is a completed successfully completion code?
So that means that the call went through the network successfully.
What is an abnormal completion?
An abnormal completion means the call did not go through. Perhaps the user hung up prior to the call connecting or a dropped call.
In terms of what time frame are all of these records kept in?
We keep them in UTC time, which is Coordinated Universal Time. So depending on what time of the year it is, you would have to subtract either 4 or 5 hours from the time that you see reflected in order to arrive at East Coast time.
On October 26th of 2018, how many hours did you have to subtract?
It would be -4.
The cell site locations indicate latitude and longitude of the cell site. Is that now there's also a physical address. Is the physical address always the same as the latitude and longitude?
No.
What could the physical address sometimes show?
So that's what we refer to as an administrative address. So we use that for 911 purposes. To get the exact location of the cell tower, you would take the two coordinates, the latitude and longitude, plot it into a mapping program such as Google Earth, and that will give you the exact location.
There's nothing further of this witness, Sharon?
Counsel, is there any cross-examination?
1 second, John.
So she's not going to go over all this stuff. She's just doing that. So I'm assuming the next one will.
Good afternoon, ma'am.
Good afternoon.
How are you?
Good, thank you.
So the technology that you just described for identifying locations, how is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to, is that what you're asking?
Yes.
So it's done with a radio frequency is how the towers work. It's a signal.
Okay, so but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct,
It connects to the tower with the strongest signal.
correct.
So how is it that you know to approximate, how do you know how far the phone is from the actual tower?
I don't,
Is there no way to tell that?
no, not through me,
Not through you?
correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
How would you know whether or not a phone defaults to a stronger spectrum? If you have a tower with a strong signal and another tower with a not so strong signal, or a signal that's not as strong as the other. You with me so far?
Yes.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described.
Correct.
You just collect it when you're subpoenaed and you provide it.
Correct.
And you're not familiar with the technology at all.
Not the questions that you're asking, correct. Sure.
I mean, that's not her job.
Is it correct that the data location information, the purpose that you worked with Sprint and with T-Mobile at some point,
I'm a T-Mobile employee.
and you were a Sprint employee at some point?
No, sir.
You were somewhere else? No?
AT&T,
AT&T.
correct.
The purpose that AT&T, and in this case now T-Mobile, collects this data location information is for billing.
Correct.
That's its only purpose.
And network engineers collect to optimize the network.
Okay. It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
Okay. Thank you.
Sure.
Thank you. Any redirect?
Yes, Your Honor. Ms. Johnson, counsel asked you, how do you know how something didn't happen? Is that a fair question?
Objection.
Sustain, rephrase.
With regards to these records, are they accurate?
Objection.
What's the objection?
Lack of foundation, Chief.
Why should the sidebar?
Another sidebar. Take a shot or do a squat. Sidebar. I mean, I don't get where that line of questioning is going. It's not something that's her domain, but I guess we'll see where this goes. I thought that she was going to be the one who like gets it there and tells us all about it, and I was ready, but she's the foundation one.
Rephrase.
No. So, Ms. Johnson, with regards to the records, does the T-Mobile keep any record of something that doesn't happen?
No.
What is contained in the records that have been provided?
Calls and text messages that have happened.
Is this from the network's perspective?
Yes.
Nothing further, Your Honor.
Is this witness excused?
Yes, Your Honor.
Thank you. You may step down. You're excused.
Thank you, Judge.
ma'am. Who is your next witness?
Jonathan Zeller.
Jonathan Zeller, please.
They say Zeller. I was so ready to hear actual evidence.
Good afternoon.
Good afternoon, sir.
Are you Jonathan Zell?
I am, sir.
Welcome. You come on up here, sir. That's our witness stand. When you get there, you put your things down, you raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Jonathan Zeller. It's Z-E-L-L-E.
Spell your first name as well, sir.
Jonathan.
Thank you.
Under that microphone, will just up or down, but not back up. Council, if you're ready, you may proceed.
Good afternoon.
I'm sorry, can we approach the third?
Another sidebar. Take a shot or do a squat. It's a sidebar. Let's see. Jonathan Zeller. I am going to pin it. I was going to put who he is, but now they're sidebarring. Oh, look, they've even got a fancy little thing up there now that says they're on a sidebar. There we go. So many sidebars. I like the way you think, Amanda. I like the way you think. Let's see. I am wanting to hear. I thought she was going to be the one that gets up in there, like, you know, like when I did the Murdaugh trial and I plotted every single thing out. I thought that's what she was going to be up there doing, and I was ready for it because I wanted to hear the actual evidence instead of just people telling me that there's evidence. I want to hear what it is. All about the data. Oh, hug a baby during sidebars. Lucy, come here, baby. Come here. Nope, she's tired. She's like, let's see.
Thank you.
All right, Jonathan Zeller.
Anything else, Council?
No, Judge.
Brandi, if you're ready, you may proceed.
Okay. Detective, how are you today?
I'm good, thank you.
He's a
Good.
detective.
Where do you work?
I work at the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the forensic, digital forensic examiner.
Okay, what is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
So what we use is a software and hardware from a company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
I've taken a few, each of them consists of 40 hours of class training and exercises, and obviously the exam as well.
What about, you taken training with the task team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know what the case.
In this case
What
that
is
we're
that?
here on today, Miramar Police Department Investigation 18-10-06269. Were you the lead detective?
I was not
What was your role in this case?
doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone with a phone number attached to it of 772-713-9807?
Yes, yes.
Prior to coming into court today, did you have the opportunity to review the digital copy of that extraction?
I did.
Okay, I'm showing defense counsel what's been marked as state's triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I did.
How do you recognize
That's
that?
what I thought
My
too.
initials and my ID number on the jump drive.
What is that thumb drive contain?
This is the generated report of the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
Here at this time, the state would request to move state's triple P in as state 64.
Objection. Yes, sir. Name. Sure.
Hey, Chip. Take a shot or do a squat. Take a shot or do a squat. Another sidebar. So 9807, that one was Melly's, I think. And then they'll tell us if I'm wrong. Ontavious Withers was 7895. Chris Thomas, which is juvie, his was 2341. And then there was the 5054 one. And I don't know who that one was. My what do you call thing you type on? Keyboard. When I'm typing, sometimes all of a sudden it'll start doing this thing where, like, if I type the word, like if I type the word Melly, there will be like 4 E's and 27 L's, and I don't know why it does that. Let's see. I have the 2341 as juvie, and Dontavious Withers 7895. I don't know if there's anything. I don't think it's sticky. I mean, I've just bought this computer and nothing feels sticky. But it only does it sometimes. Maybe I need to change the batteries. But I shouldn't have to change the batteries because, oh my God, my keyboard's been doing a shot for every sidebar. Maybe I need to, I wonder if I need to, maybe I need to start turning it off. Maybe that's what it is. Let's see. So many sidebars. Welcome back. Yes, they are back. She came back. Let's see. They have, and Wolf, they have filed so many motions, trying to get different things excluded, and their motions have been denied. They've filed a bunch of motions to get certain people to not testify, and those were also denied. They have gone through this the entire time, trying to get stuff excluded. And the state tried to get something excluded for the defense also. So of course the defense is going to bring in their own forensics people. I'll be curious to see what they say. You know, there are some forensic people who will come in for the defense, and I'm like, okay, that makes sense. You know, like if you don't have anything else to compare it to and don't have anything that makes sense, and you hear something that makes, you know, a different option, then that's great. But then you have some people that come in, like on the Letitia trial, where they come in and their expert is, I was going to say a quack job, but that's not nice. Their expert is not where it just don't make sense, you know? So I'll be interested to see what their forensic people say. You know, perfect example of that too. The staircase trial. Have y'all seen the staircase trial? Where it was, his wife fell down the stairs. He said fell down the stairs and she died, and they charged him with murder. It turns out that his first wife died the same way, and so they started looking at it, and so they had an expert come in, and there was an expert who came in and said that it was an owl attack. And he had this whole thing about that there was a tiny little owl feather that was found in her hair, and how the claw marks and all this stuff. It was crazy how random it was. But then you're listening, you're like, all right, maybe I could see it. Maybe I could see it. All they have to do, look, they don't have to make you believe that an owl did it. They have to make you believe that an owl could have done it. Very big difference. Very big difference. Oh my gosh, there's a movie now. I haven't seen the movie. I've seen the documentary and stuff, but I haven't seen the movie. Oh, Gabby Smith says Michael Peterson lived a couple houses from me. Oh, dang. Oh, dang. I thought it was plausible too. And look, I get it. If when you look at it like in just plain terms, like, okay, this guy's wife fell down the stairs and died. This is his second wife. Oh, well, what happened to his first wife? Well, she also fell down the stairs and died. Okay, well, how'd the second one die? An owl. Okay, I get it. If you say it like that, it sounds absurd. I get it. But when you actually listen to him, I'm like, all right, it's a possibility. I could see it. Let's see. There's an HBO series too. Gosh, I'm missing all these things. I watched the documentary, but I haven't seen any of that. I would like to. What's better, the movie or the series? I like Colin Firth. Let's see. Twice though, no. The first time wasn't even brought up when I watched the documentary. It wasn't even brought up at first. It's like I was hearing just about the second one, and then it was like, oh, by the way, it happened before. 4.
What's the next number?
64.
Thank you.
All right, here we
So
go.
Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extractions consist or it's done in order to obtain whatever is on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you get also by doing that, you may get items that have been deleted, and so on and so forth. That's why we do those types of extractions.
Nothing further from this witness, Your Honor.
Any cross-examination?
Yes, just briefly. How are you, sir?
Good news, sir.
You said you did a phone dump here of a particular unit that the state referred to,
That's correct.
and you have not analyzed it?
No.
You don't know if there's any relevant evidence on it at all?
That's correct.
Okay. And you don't know who it belongs to, do you?
I do know who it belongs to. Obviously, I'm in the office, I know who it belongs to, but as far as the contents of it, I don't know.
You don't know who uses it?
I do not.
You don't know who it's registered to?
I do not.
Okay. 1 second. And as to any contents of that phone, you don't know if they're texts, who authored them?
Once again, I don't know the contents of it.
Okay, Your Honor, we'd like to come sidebar if you truly.
I keep muting my microphone because they're starting to drill a little bit here. And then it's like when they're not drilling here, then they're drilling in the courtroom. Oh, goodness. Another sidebar. Take a shot or do a squat. Another sidebar. I'm going to have to mute it again if they start drilling again because they're doing the one above me now and it gets kind of loud. I feel let down again because I thought we were about to get the data again. And once again, it's just another foundational. I wish that they would just agree to, like skip all the foundational stuff. Like, oh, I'm the first one who touched it. And then I'm the mailman who carried it to the next place. And then I'm the one who created the brown bag to put it in. And oh gosh, it's so much. At this rate, we will be done with this trial by the time Portland starts in October. So we'll see how it goes. Let's see. Let's see. Well, I thought about it, but the only thing about my mom's house is she does bring me snacks when I stream from over there. But I have a lot of like chronic pain anyway from there's a lot of damage done to my insides from my from the tumor and also from the radiation stuff and the chemo. So I have pain anyway. And when I stream over there, I don't have a comfortable chair, so I kind of hunch over, and then it's like really painful after that. So I try to stay here, but they're on the floor above me. So after today, they'll be so far away, I won't be able to hear them at all. Or if I do, it'll be very little. So that'll be nice. But anytime they're on this, like, stack in front of me, or I mean, on top of me or below me, then it's really loud.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, Mr. Deans. Defendant, you need a restroom break? Need a restroom break? Nope. All right. Thank you. And what is it you all want to share with the cases?
Okay, Your Honor, and I can hand them up as I discussed them. I don't think I left one with the court. The one that I referred to first is RLG versus State, 322 Southern 3rd, 721, a third DCA case.
What happened? We don't get to hear this? Come back. Come back. Yeah, the jury left. Y'all, all this time we've been waiting, and they're finally talking, and we don't even get to hear it. It's BS. Oh, goodness gracious. I love our new sidebar emoji. Let's see. Yeah, no progress today. We've had, it is now 1:38 my time, which means 2:38 Eastern, which means, because I'm in a different part of Florida. I'm on the Panhandle. So they're Miami or Fort Lauderdale area. 2:38. And we've had two witnesses who've done nothing but enter evidence in for them to look at. That's it.
This is an app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taken 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology.
That's not actually.
Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication hurdle to, as a foundation, establish that that technology is a reliable one, because she is going to now, and she's introducing the matter for the truth, told the jury in opening, Mr. Devins, who she believes had the phone but has no proof of that to begin with, walks 70 steps. Says who? Says an app.
Right.
What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established the reliability of the technology as a predicate to the admission of that. So that is our number one foundation argument.
Your case that you want me to read?
Yes, sir.
I'm happy to take a look at it.
Thank you.
Yes, ma'am.
Here, I first start with citing back to State versus Maximit, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years, initially done by train conductors to measure out distances. It's also allowed under the Florida statutes and used to be used to measure out distances for determination of 1,000 feet from a place of worship, a school, or anything else, for measuring distances for enhancement on drug penalties. So I'd start by handing that one to your honor. Then I also have State v. Birch, which is a Wisconsin case in which similar information was admissible and used in a homicide case. Then also the issue of cell phone dumps, and that's at 398 Wisconsin 2nd 1. And then even more recently, this was a federal case, United States versus Riego, R-I-E-G-O. I just have a Westlaw site because it's 2022, it is not yet. This is 2022 Westlaw 175467114. And again, those discuss all of the location information and the activity and Apple Health data that was admitted in those cases. And I'll be happy to email copies of those to defense counsel now.
Thank you. All right, we're in recess. I'll read them all.
Your Honor, may I also just direct your attention to a few articles, one of which indicates the highlight here. The reliability of the registered distances, however, depends on a number of factors, including walking speed and walking style of the subject, and can deviate up to 30 to 40% from the true value. That's one of the several articles here. And what I will do is I will compile the articles and send them all back for your review while you're considering the issue, if you don't mind.
Sure, and the state would also submit in terms of law review articles, including a 2016 wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone health app from a forensic perspective can steps and distances registered during walking and running being used as digital evidence. And I would direct our attention to the Supreme Court of Alabama. That was Jeffrey West. The individual in that case was convicted as well based on some of the Fitbit data.
And may I just ask if the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology, it's just put in?
It has been admitted, and I have some of the, send everything that I'm giving to His Honor, copy to you as well.
Thank you. We're in recess.
Thank you, Judge.
Lordy, lordy. Yes. Okay, so two things. One, if I were in Melly's position, I would want an attorney like his, because he tries to keep everything that is really damning for his client. He tries to keep everything out of there. And
when a juror is pulled out of the jury room, sat down.
Oh, hush. We don't want to listen to you. So if I were in his position, I would want that kind of attorney. No, I don't care who's on what side. Everybody's going to have their own opinion. I don't care. As long as we can all talk about it civilly here, that's the only thing I care about. Just, everybody can think what you want. But no matter which side you're on, you have to admit he's a good attorney. Now, about that step data, it's funny because actually one of the things that let me pull this up. I think here, let's see. I think I have my, okay, so yeah, let me see if I can't I make that bigger? Maybe not. Okay, so see these little, this is my Murdoch chart. I thought I could make this bigger, but honestly, I don't know how. Oh, here we go. Look at me figuring stuff out. We can even go bigger than that, can't we? There we go. Okay, so this, dang, just did it. All right, so this is my Murdoch chart, right? Make sure that that's still showing. All right, so see these boxes where this is the steps? The step data was used in Murdoch, and there was actually, when I was going through all this, there was a SLED had a mistake in their step data, and I submitted it. I gave it to an attorney who I'm friends with on Twitter, who's close to the Attorney General. And anyway, it all got corrected and admitted into evidence and stuff. Do you know why? Because it is important. It is important. It is accurate. It like to a it's accurate in the way that like I said when we were first talking about this, that it is good for patterns. Now, is it going to be the most accurate thing as far as it'll, if it tells you that you walked exactly 135 steps, and that means you walked exactly 135 steps? No, but it is going to be there to recognize patterns. So, for example, when we look at the Murdoch stuff, all right, all of my little boxes right here are their steps and their step per minute, right? So if you look at the times when Murdoch was just normally walking around, everything's, normal, whatever, like 7.3 steps per minute, 20.34 steps per minute, 63.12 steps per minute. So it gives you like an example. It gives you a kind of like a pattern. Now, let's say if I stand up right now, then walk 10 steps over there, does that mean that it's going to show 10 steps? No, that's not what that means. It might take me 10 steps for it to even turn on. So by the time I get over there, it might not even do anything. But it's all about the pattern. So the reason that they are wanting to put this in here is because the 70 steps that he walked the two different times are vastly, that pattern is vastly different than the like 1,400, almost 1,400 steps that he walked later. So that's why that's important, because they want to show that, there was a reason that during those 11 minutes between when he dropped those two pins that, that there were so many steps. So now, having said that, the defense keeps saying, we don't know that he had his phone. So that's one of the things that, that's one of the reasons I really want to see all the phone data, because I want to know, if he didn't have his phone, I want to know how they know that. I want to see if they can give me any doubt, or if there's too much stuff on the phone data for me to have any doubt that he had it. Right now, it's looking like he did, because of the FaceTime call and dropping the pin to, to Fredo Bang and all of that. So right now, it looks like he had it after. But I want to hear all the data that shows me that, whether or not he had it. That's what I'm ready to hear. But the step data, I know he wants to keep it out because it's very damning evidence, but it's used in trials. This is not a new thing. Let's see. Let's see. Danielle says, yeah, I think whether he had his phone or not should go to weight rather than admissibility of the evidence. Jury should decide. Yeah, I think that they need to oh, are we coming back? Maybe. Are we coming back? No. So I want to see everything they have. I want to know everything about everything so I can make a decision. Because you can't make a decision unless you know what all there is. And I think we know the jury doesn't get to see everything, but think in order to make a decision, it's good to have as much evidence as you can, but also it does need to be fair. Like if, like, let's say, okay, we know step data is for a pattern. I think that as long as it's explained that, hey, this doesn't mean that if it says 10 steps that you took 10 steps, this means that, these are patterns or whatever. I think if they understand that, then they can make their own decision based on the weight that they put on that. Like you're saying, I think that as long as it's explained that it's not 100% accurate, but that it is accurate as far as patterns and stuff go. Let's see. Kevin Ball says you can add steps by just moving your arms. Try or put on your iPhone. I just did. Mine doesn't, because I tried that with the Murdoch stuff when I was going through all this. I tried a bunch of different stuff, and mine does not do that. It takes actually more steps for mine to start picking it up than anything. So if anything, mine misses steps. Let's see. And one of the things too that we know about the step stuff, because Lord knows any of us that watched Murdoch, we went through all this for over and over. The number of steps can vary. Okay, so let's say if you're walking and you lift your phone and you're looking at your phone while you're walking, it may not register steps while you're doing that. If you have it in your pocket, it may still register steps, but it'll register them at like a lower rate than if you have it in your hand and you're swinging your arms. So there are variables that, again, this is patterns. It was very damning in Murdoch, and that's one of the things that when I mapped everything out and put it on there, it made it so interesting because you have at the times when it were those critical times, the pattern was so much more, so many more steps. I just showed how unreliable step count is. I have just said that there's a bunch of variables in it, that this is used for patterns. It cannot tell you the exact amount of steps that you took. It tells you the patterns. Let's see. Brenda says, y'all, I'm sorry, but it's still more to Murdoch case. What do you mean? What do you mean it's more to it? Let's see. You believe Murdoch didn't do it? Interesting. Let's see. Casey Smith, we are in another recess. We're waiting on them to come back. We're in another recess. Brenda says, I believe he knows who did it. Gotcha. I believe he did it. So that's one of those agree to disagree. Let's see. But you are not alone in that. A lot of people think one way or the other. If you attach the Fitbit watch to a drone, would it register anything? I'm not sure, but that's you know what? That's one of those things you do that and record it and we'll play it before court one morning. Let's see. They're going over the admissibility of the evidence that defense does not want in about the cell phone stuff. So the judge is looking. Hear them? They're back. Okay, I think they're done. Oh, nope, they're not. Oh my God. Okay, I think they're done for now. Let's see. Yeah, they've gone over this before trial too, but they haven't. There hasn't been any reason for them not to, or there hasn't been any reason for them to exclude the evidence. So now to exclude her from trying to bring it in. So now she's bringing it in, and he wants to keep it out. I am what they call NED. So right now there's no evidence of disease. I am hoping, I've got 2.5 years now. I need to go get checked again. I have to get checked every 6 months. But once I get past the 5-year mark, then I will be considered in remission. Slowly inching right along. But I'm done with chemo, done with radiation. It's been 2.5 years. Now I'm just dealing with all the aftermath. Let's see. Yeah, I wish that they could have taken the time to just be like, hey, you know what? While we're waiting on the juror, let's just go ahead and fight about everything that there is to fight about. Oh.
Number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the.
I thought they were back. They're just replaying. That's no fun. Blessed Mom from Texas, sending you love, Brandi, praying for you. Thank you for the best stream around, and mods rock love to you all. Thank you so much. I appreciate that. Thank you, thank you, thank you. Our mods are the best. What are we going to do when the construction guys are gone? Like, how is it? I feel like we're going to miss them when they're gone. I feel like we're going to be like, oh, remember when we used to have, because remember before I knew that it was them putting the doors in, it was just that constant drilling, and we thought it was like At first we thought it was construction. They were like, okay, it's too much. Maybe they're like doing like black market dentistry in the condo next door or something. What are we going to do when they're gone? What will I do with peace and quiet? I won't know how to act. Let's see. There's no date for the verdict because there is no verdict watch at this point.
The state took issue with it, raised a Daubert objection to it at that time. This is not a situation where the state presents us an expert. And we can't anticipate that the state is going to try to admit evidence before they admit it without the necessary predicate. And those cases actually speak to the objection being made at the time that it is sought to be introduced. As a matter of fact, some of those cases rejected the appeal because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a Daubert objection to an expert who's testifying. He doesn't purport to be an expert. This is not a Daubert situation, Judge. This is a lack of foundation situation. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a Daubert question. It's a foundation question. And before the state, I think those cases are clear. If the state is planning to put evidence in that relies upon the technology, they first have to establish the reliability of that technology. And that's the basis of our objection with respect to this step data. We've also made a relevancy objection to the fact that there is a wholesale dump of information coming in through a witness who said, I haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant on a 404B? How do we know that it's not doesn't contain 404B evidence that's inadmissible? The state has to establish the relevance of the information they seek to put in. They can't just put in everything from a phone and pick through what they think, and then the jury has in its possession a host of majority information that's not relevant to the proceeding, which is prejudicial. So that is the other basis for our objection. Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sack Chaser Howard. Sack Chaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamell Demons. It was retrieved from Jameson Francois, not Jamell Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter, all the information they're seeking to put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before I didn't wait until after, because one of the points that the court made is you already let it in. We objected before, Judge, and you told us overruled, let it in. It's still a problem right now, and we're trying to stem the damage before it goes too far. And we think that the issue has to be addressed before this information is used and it goes forward, both on the foundation issue, on the technology issue, authentication issue, relevancy issue, 403, 404B issue.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
The phone itself?
Yeah.
That will be introduced through the.
No, where was it? Where was the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
And they have to establish it before they put it in, not after the fact, on this notion that they possess information that makes it relevant. If they do, present it, and then it's relevant at that time. We have, Your Honor, indications of this cell phone and this Instagram account that the state has introduced. The Instagram account is being used to post pictures days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people. This notion that, oh, it's his account, he's an artist. It's a public account that several people have access to.
I'm sure you're going to be able to ask those type of questions, counsel. My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's how it's not, the methodology is, and basically a Daubert issue on it. It's not clear, it's not been established, all those types of things. That should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial than probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying it's something more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it. All right, so it's admitted.
Okay.
All right.
Thank you.
All right, bring the jury back in.
Mr. Process, Mr. Howard, are you finished with your cross? Or are you have additional questions? Yes.
I don't think he has any relevant information. He said.
So you're finished?
Bring the jury.
Let me ask a few.
Interesting. All right, so now we're finally going to maybe get some information in today. How long? We're going to time it. I'm going to put on a timer when she gets on the stand, or he, whoever they're calling. And as soon as they're sworn in, I'm going to start the timer. And we're going to see how long or the stopwatch. Now I'm going to see how long it takes before the first objection. Candace says 1 minute, 45 seconds.
Jury entering.
MJ Lynn says 1 minute. Object on what grounds? 2 minutes and 26 seconds. 2:15, 75
Ladies and
seconds.
gentlemen, thank you. For the delay, please be seated. Let the record once again reflect the verdict of the defendant, this counsel, the assistant state attorneys. Ladies and gentlemen, jury, all witnesses remain to stand.
All right. Oh, same witness. Okay.
Yes, I have a few more, Your Honor.
All right.
Thank you.
All right, we're going.
You did, sir, 2 data dumps from the device in question.
I did 2 or 1.
You did 2 of them, did you not?
I did on this device, I did 1 extraction,
You only did it once?
if I recall.
Did you have the data verified by any third party for completeness of the download?
No.
And you made that decision, was it your decision whether or not to do that kind of verification?
Yes.
Okay, and you elected not to?
Correct, I did not.
Did you have an engineer review any of the data that you retrieved?
No.
I've never heard
And
of
have you validated that the Cellbrite extracts in the data that you did were in fact complete?
The extraction is the extraction, and that's what I got out of it. That's what the machine gave me, yes.
Okay, and how did you verify that the machine gave you a complete download?
I understand when you say a complete download.
You said you don't understand what I mean?
No, you can elaborate on that.
How did you verify that the machine, the Cellbrite software that you used, downloaded the contents of the phone in its entirety? How did you go about verifying that?
That is not something that I can verify. That is whatever the data that comes from that phone and appears on the software, that's what I have. That's what I can do.
Okay, so you can't verify.
I cannot.
Is there a process of maybe testing, is there another, first of all, software that you can use to download the information?
Sure, there's other software.
And you only use the Cellbrite?
Correct.
And if you use another software and compare the downloads, that would be one way for you to test it, whether or not the download was complete, right?
In period, I guess so, yes.
In actuality.
All right, I'll stipulate that.
Okay, so when you say there's no way to do it, it is what it is, what you're saying is there is a way to do it, and you didn't.
If that's what you want to call it, but it's not true. That's not correct.
Oh, so you did test it on another software?
No, I did not, but this is the only software that I have available to me.
Okay, so it's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available.
Well, correct, I did not do it, no.
Do you know anything about the testing of the technology of Cellbrite as to its efficiency and operability?
No, I don't. I'm not an engineer for them.
So you, pardon me?
I'm not an engineer for them,
Okay, so it would take an engineer to do that?
or somebody from that company, not me.
Okay, so it's like any kind of software. If you have the software and it doesn't work in totality or it doesn't work completely, you're stuck with the answers.
I'm not understanding what you're trying to get at, but if you rephrase it one more time, I appreciate that.
If that Cellbrite did not give you a complete and accurate download, you would have no way of knowing it.
That is correct.
Okay, because you didn't have comparable software or similar software to test the results against.
Correct.
Okay, so you're just trusting in the faith, you're just having faith that the Celebrite,
Sustained.
you are relying upon the accuracy and completeness of the Celebrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
Okay. Have you ever done a data dump from a phone more than once? Any phone?
Yes,
On Celebrite?
yes.
And was it a phone that left your possession and then you regained possession of it?
When you're saying left my possession, I'm sorry.
In other words, it left the custody strikeout. In the instances when you have downloaded information from a phone on using Celebrite more than once, I presume you did it for a reason.
So one of the reasons why I probably would do it is maybe a software update from Celebrite.
Okay, that's one of the reasons. What else? What are the other reasons you might do it?
That's the reason that I would use it.
Okay. Can I have one more, Kiana?
Yes.
I don't think I've ever heard anybody question the completeness of Celebrite. I've heard them question the completeness of downloading if it wasn't Celebrite, but I've never heard anybody question.
So it is your testimony, sir, that you didn't do an extraction from this phone in June. What year is this? And then another at a later date?
I don't recall.
Or at an earlier date in April?
I don't recall.
Oh, you have any information there before you? Any of your reports that would indicate that?
I have one that was completed on February 28th.
February
2019, I think it is.
Okay. Nothing further. Thank you.
Councilman Zay, redirect.
Briefly, Your Honor. Detective Zeller, counsel asked you whether or not Celebrite is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection?
What's the objection?
This witness has already testified that he can't speak.
Sustained.
So Detective Zeller, in terms of you've used Celebrite numerous times,
That's correct.
approximately how many?
Hundreds.
Have you found any instances in which Celebrite added data to a forensic download or dump that wasn't on the phone itself?
I'm sorry.
Objection?
What's the objection?
You would have no way of knowing that.
Overruled.
Can you ask it one more time? Sorry.
Have you ever had an instance in which Celebrite has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone? Not that I'm aware of.
In terms of the way to physically review, how would you do that on a cell phone and compare it against a Celebrite extraction?
Well, there's a couple things I could do. I could look at the different artifacts that are extracted, meaning, so I would look maybe at a particular phone call was made at a certain time and date, or a certain picture that was there at a certain time and date, or a video, or so on and so forth, whatever that's there. That's one way of doing it, yes.
So I want to make sure I'm clear. Are you saying you would look at outside evidence from the phone and see if it agrees?
Correct, yes.
In terms of the information and the data that's put out there, what is the purpose of taking it off the phone?
Well, you also don't want to use the original, and just pretty much taking a copy of the phone so that you don't ruin anything, delete anything, or compromise the device, or anything of that nature. So you work off that copy.
In terms of when the phone is brought to you, Are there steps that are taken to make sure that there's no outside or internet or network access with the phone?
Yeah, so usually the phones are put in what's called airplane mode, where you disable all cellular connections.
And in terms of the type of extraction that was done in this case, what type of extraction was done?
This is called an advanced logical extraction. So
What does that mean?
So there's different forms of extraction. The advanced logical pretty much gets, for the most part, I'm going to use the word everything on there. When I say everything, meaning the context, the pictures, the videos, the communications, any sort of communications that are on there, deleted items, specifically deleted items.
Okay. And in terms of to get the advanced logical extraction, what information do you need as an examiner?
Meaning, I'm
Do
sorry.
you need the passcode to the phone?
Yes, you do the password, correct? Yes.
Nothing further now.
Is this witness excused?
Yes, sir.
Thank you. You may step down. You're excused.
Thank you, sir.
Thank you. For your next witness, please.
Brendan Collins.
So he was the digital forensic examiner. I'm gonna try to grab some batteries because I can't get my keyboard to work properly.
Thank you. You, Brendan Collins.
Yes, sir.
Welcome. This is our witness stand. Can you go over here, please? When you get there, just remain standing for a bit. Raise your right hand and be sworn.
You solemnly swear or affirm the testimony that you give in this case shall be the truth, the whole truth, and nothing but the truth.
Yes, I do.
And state your full legal name for the record.
Brendan Collins.
Please spell your first and last name for the court report.
My first name is spelled Brendan. My last name is spelled Collins.
Thank you. Please be seated. Collins, that microphone in front of you, adjust it up or down.
I missed his name.
Thanks, sir.
You ready?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Mr. Collins. How are you?
Good afternoon, I'm doing well.
Collins.
Where are you employed?
I'm an FBI agent, so I'm employed by the Federal Bureau of Investigation, and my full job title is Supervisory Special Agent.
And how long have you held that position?
This current position, about 18 months. I've been employed by the FBI for since 2012.
And as far as education, what types of degrees do you hold?
I have a bachelor's.
And is it in a specific area?
I was a history major in college.
Were you employed anywhere else prior to working for the FBI?
By the Army.
And how long were you employed by the Army?
About 6.5 years. I had a couple of different jobs.
Okay. Going back to where you're working now, the Federal Bureau of Investigation, what are your responsibilities as an FBI agent?
Well, agents do all sorts of different things. Generally, agents are all investigators, and in the FBI, we investigate a myriad of crimes, from violent crimes, economic crimes. We also have national security mandates. Me specifically right now, I'm the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
So CAST, or the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check your email, post something on social media, that's to connect to a cellular network or through the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. And that will say that the initial records, like a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. Will say, this date and time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record about the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the earth. You put those two things together into some sort of mapping software and it plots it, and then it will give you a general area where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
So the records I have are just about devices.
Okay. So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as well?
Yes.
What is that?
To be CAST certified is pretty extensive. There's several stages that the certification process is broken into. So I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAST work in your day-to-day cases? Before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
No, no, on a, but there's a lot more training than just that 2 day thing. Is that okay?
Oh, well, let's start with, to do that first 2 day training.
Yeah, so the first.
Is that mandatory?
Yes.
Yeah.
Yeah.
To go on past that,
Yeah.
is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training?
So the next course is called the advanced course, and it's a week-long course. And that's just a more in-depth dive into each of the networks. So specifically, what are the uniquenesses of, say, Verizon or T-Mobile, AT&T, Sprint, when it was a standalone provider? What do their records look like? What are the uniquenesses of their network's designed, et cetera. After the advanced course, then we have a sort of test. It's like a week long. When I went through, it was a mix of part in the classroom and part in the field, but it's all scenario based. So, for instance, you'd be like a kidnapping scenario, like, hey, this child was abducted. Your job is the asset going through to try and use the records to develop the search location and say, yeah, I think that we need to go here to try and recover the child. You do a portion in the classroom, you do a portion in the real world where they have test runs set up at different locations and you validate the results right there. So you either find the person or you wouldn't. And at the end, you either pass or fail. So I passed and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have like a week that's basically a semester's worth of material condensed into a week. It's put out by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about these are the types of records that we keep in our specific record, our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, so like the Sprint Network Operations Center, where they oversee the management of the whole network across the country, et cetera.
And then at the end of that, there's a test, and you either pass and are certified, or you don't.
Okay, so Special Agent Collins, are you certified in CAST analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes, so to keep your CAST certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBF?
No.
What other agencies and I guess companies do the training for you?
Yeah, so we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics. I mean, anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works, training on that?
For what?
In terms of being a CAST certification?
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call detail records analysis?
So call detail record analysis is really like the bread and butter of what CAST does. So since I started the training process in 2017, that's it's when I first really got exposed to working call detail records or CDRs.
Okay, and approximately how many times have you done this type of analysis?
I've done more than 130 cases and that have included more than approximately 300 sets of records.
When you say a set of records,
Yeah.
What does that mean?
Like a call detail record or an engineering report, some sort of data report, some sort of report from a phone company about a particular device.
And in terms of the types of cases that you've worked, what have they been?
Again, violent crimes like homicides or shootings, white collar crimes, and then public corruption, crimes against children, terrorism.
Okay. Have you worked cases where you've been called upon to determine the location of a cell phone?
Yes.
How many?
I mean, for the 130 so cases that I've helped with, the vast majority of those have to do with location, historical location of the phone.
Have you had the opportunity to validate your historical call data reconstructions or that you do?
Yes.
And how do you do that?
Well, as we mentioned sort of during the, I was talking about the train up, if it's a situation, a case where we're trying to find someone who we believe is in possession of the device, and you do an analysis and you say, I think we need to go to this house, and go there and the person and the phone are there, that's validation. If we have a case where we have some sort of other evidence that corroborates it, like crimes against children case, and there's metadata on media that was produced at a specific location, and a cell site that says, okay, we know this film or something was produced here, and here's what the cell site looks like, that corroborates it. Yeah.
So when you say metadata, can you explain what that is?
Yeah, that's outside of what I do with CAST, but that would be something that would be in a media file perhaps, that somebody else, if you extract the file from a phone using a physical extraction device or a computer or some other device, sometimes there's metadata embedded within the image or the video or whatever that will tell you different things, such as when the picture or movie was produced, where it may have been produced, or the picture may have been taken, etc.
You're just going to offer Special Agent Collins as an expert in the area of historical cell site and cellular technology and offer for water.
Hey, you want to come start up, sir?
Take a shot, do a squat. It's time for a sidebar. Big surprise. And somebody had just said that he's doing well with no interruptions. But the only reason there were no interruptions is because he wasn't going over anything specific yet. Flip-flop count right now, we are only up to 2, but we restarted after the break. So we've got 2 flip-flops right now. So flip-flop count is at 2, and sidebar count is at 7.
Thank you.
Thank you. Can we arrange for a restroom break for Mr. Demons, please?
Yes, sir.
We'll be in recess.
Recess! Seriously? What? What? Seriously? Y'all. What is this life? What is happening? Recess. We have had, you know what though? You know what? This will make my recap really easy. What is this? Court is in recess. Again. What? He could have taken a restroom break during any of the other bazillion breaks. What is going on here in this world? Joshua Coster says, took a shot, did a squat. I fallen and I can't get up. Well, you know what? This has been a day. This has been a day. I feel like we've had, 3 witnesses so far, and all 3 of them were just foundational. We haven't actually gotten any real information yet. You know what's ironic though? We were thinking that like today was going to start out with like this big, like this possible like big bang moment, like they're talking about the mistrial and stuff. And we have had no bangs, no big bangs today. None. It's just been lots of potty breaks. Oh, Lord, help me. All right, so this is interesting. Oh, hi, Ivan. Oh, we got an RA raid. Y'all, come on. We're in recess again. That's all we do here. We break and recess and break and recess. Okay, so of the witnesses we've had today, there's been a whole lot of nothing entered in so far. Yeah, this is we're easing into this trial will be easing into October for sure, because by the time Portland gets ready to go on trial, maybe this one will be finishing. So we'll see. Mike Savage, I wish there was this much recess when I was in school as well. I sure do. Hello, everybody from the RA raid. Welcome. Come in. Welcome. Oh my goodness. This is crazy. So I thought when they brought Susan Johnson from T-Mobile, I was like, yeah, T-Mobile, this is it, y'all. This is the moment we've been waiting on. We get to see like actual evidence, and then we can listen to what they say and make up our minds. Come on, Susan Johnson, give us the good stuff. And Susan Johnson was like, yes, I work for T-Mobile. These are the Sprint records that I checked. Now you're dismissed. Of course, there were 27 sidebars and 14 recesses in between those two sentences, but that's where we got with Susan Johnson. And then, and of course, him asking her about radio frequency and the towers, which she said, I'm not an engineer. And then we had Jonathan Zeller, our homicide detective, and he's talking about the Celebrite. We're like, yeah, here we go. All right. This is it. This is the Celebrite. Yes, we're going to hear everything. Nope. Still haven't heard anything. Whatever. I feel like maybe they just should have been like, you know what? Let's call it a day. Let's send y'all home. We'll work all this out behind the scenes, and y'all enjoy the day, and we'll just catch up with you tomorrow. But that's not what happened. Okay, but I will say this. Moby / Edward Norton is very qualified to tell us something. We just have to wait on it to happen. Oh my God. Oh yes. Yeah. She's probably like, I ran to the hospital for this. What the heck? I think they've just given up on the day, possibly. Who knows? There's so many recesses. Let's see. This trial is never going to end. You know what though? For real, because there are no court days on the docket for Friday. So we are only doing Mondays through Thursdays. There's and I double checked that. There's no Friday court listed on the docket at all. And the week of 4th of July, there's no court. Which is nuts because you think about it, there's no Friday to court before that, and then there's no court the following week. I mean, it's going to be like 12 to 18 business months before this is all over. This is crazy. Well, they are on a short recess. Again, I have to fold my ear over. It hurts with these. These things hurt. I need to figure out how to adjust them. They're on a short recess again, so I'm not sure how long they're coming back. They don't have a timer up. Craziness. Oh, yes, Ivan, I saw your tweet. That's really funny. It's really funny. What trial is next? Well, that depends. Because if this one doesn't end until like 2039 or something, I don't even know. I'll tell you what, whatever trial is next, that crime hasn't probably even been committed yet. That's the rate we're going right now. Gracious alive. Hello. We love our lurkers too. Yeah, they've basically been in recess all day. They come back, get our hopes up, then sidebar, and then recess. And that's it. Oh my gosh, Pam, me too. Okay, so Pam says, oh, good. I'm glad there's not going to be court. I'm going on vacation that week. And I was sitting here trying to figure out how I was going to watch and enjoy my vacation. Me too, because I was worried about how I was going to get the stream handled while I'm gone that week. I'll be on a boat, and I love y'all so, so much. And I love spending time with y'all, but I don't want to.
Sure.
Time out of my
Are you
vacation.
intending to seek to admit durable?
Yes, and that's what that,
Admit durable.
yes, and that's what that,
Should we just object now that reports are inadmissible?
I don't know what you're speaking of.
I don't think we admitted to admitting for court, we said we would
Excuse me,
agree.
I only want to hear from one. Whose witness is this going to be?
This is my witness, Judge.
All right, so you make the objection. So this is an order on the admissibility of expert witness testimony by Federal Bureau of Investigation Special Agent Brandi Collins. Let me read it. This is your order to the judge. Says your defendant stipulated to the admissibility at trial of the expert testimony of Special Agent Brandi Collins in the area of cellular phone forensics. This stipulation includes Special Agent Collins' testimony regarding the cellular analysis survey team task report. And based upon the defense stipulation, it is ordered and judged that Special Agent Collins' expert testimony in the area of cellular phone forensics and on the cash report is admissible at trial. What's the issue?
So I believe counsel is trying to state that we are going to object to the admissibility of the CAS report. We have stipulated to his testimony after deposing him. And then I will also bring to the record, she's trying to bring in 3 different CAS reports. When we had deposed Agent Collins, we only had deposed him as to 1 CAS report. We had extensive conversations about whether the state would be bringing in the additional CAS reports. We had agreed at that time, if they were going to bring in those reports, she would let us know and we would depose him again. That never happened. We were always told it would be the 1 report of the 2 phone numbers.
We're objecting to the admissibility.
And which we are objecting to the admissibility of those reports based on hearsay. Also, they are misleading, and also the information in those reports have not been properly validated by an engineer.
Okay, so as of April 4th, 2022, what report was in existence as far as Special Agent Collins?
so the first one that was with regards to Anthony Williams' cell phone, as well as Mr. Demon's cell phone. That one was
What
done.
other reports are out there?
The other ones were generated in May of 2022 and immediately turned over to defense counsel, and I have a very different recollection of that. This was listed at the same time as Mr. Zeller that we just had, so there was never any additional office request to depose this witness. But Special Agent Collins has been available for the last however long if they so chose to do so.
And Judge, I would just for the record make an objection to her characterizing that particular phone that is actually registered to J.D. King as Mr. Demon's phone. I don't believe that has been established.
Thank you. So what is the report?
Judge, I'm sorry, I didn't hear what you said.
I asked for the report. I need to know what the report says. I'm not familiar with it.
Yes, sir. So they're all substantially similar. They do different cell phones at different times. That one is the one of Mr. Demons and Mr. Williams, explaining how the cellular,
Objection.
explaining how.
I don't understand. I'm asking for what the report is. I want to see it. You say objection again. What's your objection?
My objection is to the characterization that it's Mr. Gibbons' phone
Thank
and Mr. Lincoln's phone, actually.
Ms. Brandi,
Yes.
do you have another copy of the report?
First, emailed it to Ms. Liberty.
I'll give it to him.
Thank you.
They don't want them calling it Melly's phone because they don't want it to be Melly's phone. Because then all that evidence from that phone can be used against him.
So what is Agent Collins going to do?
Agent Collins would testify as to how he does the analysis, how he generates those timing advance bands, and what it means as to the location of the cellular devices based on the records, which is all done as a product of the accuracy of the records and the fact that the cell phone communicates in a consistent way based on the laws of physics with a cell phone tower.
Because in here, it talks about the phone 772-713-9807. T-Mobile says Jamell Demons. This goes below 954-248-9081. T-Mobile Anthony Williams. And it has the date of the report being May 12th, 2022.
Yes, Your Honor.
So this report date is after the order date.
It is. That is the second. It's the same one. It was all done at the same time. I believe, if I'm not mistaken, there was a typo that had to be finished on the spelling of the defendant's name, which is why it was generated at a second time on that point. Absolutely.
May I respond to it?
You respond, you say what you want, counsel.
I would just say the simple fact that it has Mr. Evans' name on it, Mr. Williams' name, that needs to be subject along with the other three reports, which were actually filed after the post-em. It is my recollection that we were told in court that they would not be used. There was a question if Jameson Francois' CAS report would be used. She didn't give us a definitive answer. We finally rested on the fact that she was not going to be using Mr. Francois' phone. So it is a little bit of surprise that is now being introduced at trial. And the other one, I believe, with Withers, we never ever discussed it.
Hold on. Hold on.
Yes, sir.
I don't fully understand this order dated April 22nd. It says, order to judge Special Agent Collins' expert testimony in the area of cellular phone forensics and on the cash report. So he's going to testify. I wouldn't normally admit a cash report. I don't see why it would come in here. I don't see this specifically saying it's admissible. I see it saying Special Agent Collins' expert testimony in the area of the cellular phone forensics and on the cash reports. And so he can testify. He's here. You can ask him questions that you want, but I don't believe I'd be letting this into evidence. It's just, he's here. His testimony is his testimony.
And so, with regards to that, the necessity of the maps is that the Special Agent Collins is going to testify in terms of latitude, longitude, and distances on that. Without a map, and using that for the jurors to be able to understand where this is being placed on the actual map, that's going in a vacuum.
He can show it as a demonstrative aid if that's going to help him illustrate his testimony. I don't have an issue with that. That's a different question to me. Typically, we don't just admit an expert's report. The expert's here is going to testify.
Yes, sir. Sorry.
And it's not clear for me from this order that that's what Judge Siegel anticipated, that the report was coming. I don't have any issue regarding his testimony. They're not even, the defense indicated they're not even going to board hire him regarding his qualifications. So, he's able to testify. But as far as the report coming in, I don't read your order that way, respectfully.
Understood. So, Your Honor, then if I can show the admissibility of the maps with that on there, then you would evaluate them as their offered individual.
I don't have an issue. I mean, if he's able to identify them and talk to them, that's a different issue. You're wanting to admit the whole report in as the way I understand as substantive evidence. And typically, that's not the way it's done. I mean, the testimony is the testimony of the witness, not the report. Otherwise, it's cumulative, it's duplicative, or whatever he's going to testify to. I don't see the order talks about a date in April. This report was given after that date. I don't know if this is what the judge intended. You said there were some amendments. I don't know what the amendments are. I don't know if they were approved by the defense. They're saying they're objecting to it. Typically, that's just not done the way it's being done, putting in the document.
So, Your Honor, there are a number of cases on that specific issue, which I'm happy to provide the court.
What specific issue? About a report coming in?
About the maps and the mapping being admissible. So that would be.
I'm not concerned about the mapping. I'm concerned about the report per se.
Well, I just want to make sure we're clear on what specifically. So some of them, this specific items are demonstrative on that. So for example, when I can put it up so everybody can see, so it's clear. So Special Agent Collins, I would anticipate would testify that, for example, there is cell tower usage and how that would be displayed on that. So that wouldn't be confused with cell site usage. So that's because there could be the possibility that a juror would think, well, this is showing that the phone is somewhere in this purple area, which would not be correct, as opposed to, for example, a timing advanced illustration, which in this case, the witnesses can testify that the phone is somewhere in this band based on, and then as well as, so in terms of the way the mapping is then done, to make it clear and understand that these red dots are not the specific locations, but rather the towers that are used. I think it's important for the jurors to understand that and have the first part of that analysis there so that there can't be any sort of improper recall by the jurors on that. So then as to the locations on those, then this would be one of the timing advance. So if they don't have the other first part,
Which I think is renewed again.
Excuse me, counsel, I don't think she's done,
Okay, sorry, Judge.
so it's more
Bradley
so
done.
the fact that the timing advance data and the way it is done, I don't want there to be any confusion to the jurors to saying that this is overstating the evidence. So if I just put in these particular items without the full explanation, because I don't think it is appropriate to do so without the jurors understanding the limitations of the testimony and what the different maps show. So on that would be the specific parts the state would be seeking to introduce, because the locations of the towers are important to how the math is done.
My understanding is the defense is objecting to that exhibit, is that correct?
Yes, Judge.
Does that include the maps?
That does include the maps, Judge.
So they're objecting to it, so I guess you have, in some way, it has to come out how it was done.
Mhm.
And you can talk to the witness and see if he can, authenticate it. Originally I was thinking that you were using it as demonstrative, and I would ask him if that helps it alter his testimony or not. But if you're saying you're not concerned with that, you want to admit them into evidence. So the objection is, what's the objection?
That it's irrelevant. I would also object to the fact that
That it's not relevant?
it is not relevant. It's also referring to Mr. Demond's phone. Nobody's established that number was his. It's referring to Mr. Williams' phone. We've got no testimony that establishes that it's Mr. Williams' phone. If we were to go to the other two reports, I don't know how the court's ruling on them. Again, she's referencing phone numbers, assigning them to people. We have had no testimony or evidence before the court that those actual phone numbers belong to those individuals.
Thank you. So I haven't heard any phone numbers being assigned to any individuals.
If I may, Your Honor,
Sure.
that is why the state introduced the phone slip that has been brought in to the defendant's fingerprint, that he endorsed that as his telephone number, and as such, the state can now argue that. As to all of the other individuals, those are coming in from the phone records themselves. For example, Dundevius Withers and Chris Thomas, as I went through with the Sprint records custodian.
So let me start. What is the phone number that's on that corner sheet that you're saying is Mr. Demis?
772-713-9807. And that's why we had the fingerprint analysis done, and they came in and identified that as the fingerprint of the defendant.
Thank you. And what's the next phone number?
The next two phone numbers that are the easiest ones to go through, Your Honor, are the phone numbers of Christopher Thomas, 772-713-2341. And if Your Honor recalls,
713341. Should be another number.
772-713-2341. And I can bring up here for Your Honor the specific information on Mr. Thomas's phone that was brought in earlier through the Sprint records custodian. And there's the phone number at the top of the screen, 772-713-2341. Billing address for Chris Thomas.
All right.
Going down in the same records, because they were produced at the same time. In addition, the email address with it is Chris Thomas 86. Again, consistent with Christopher Thomas. The next phone number that is on this particular is 954-371-7895. And that is belonging to an individual by the name of Dundevius Withers.
Are there any other phone numbers this witness is going to be testifying with?
Yes, Your Honor. He would also be testifying on the T-Mobile records to the individual by the name of Jameson Francois, and to go to the subscriber information for Mr. Francois's phone. This is related to Miss Adria Scott, which there's been testimony that Adria, or AA, is the wife of Jameson Francois. In addition, that phone number for Mr. Francois, 954-376-9158, is consistently in the phone download of Mr. Demons and is listed as tracked. And there are plenty of photographs and things of that nature that would show and illustrate that Mr. Jameson Francois, also known as Track, is the owner of that phone number.
But it's actually in his wife's name.
Correct. And if you, the rest of the subscriber information also says it is a family plan with multiple lines. Rate plan, family, unlimited, 2 lines included.
On the subscriber information for the first phone that you're suggesting is Mr. Demons, what does that subscriber information reflect?
That comes back to his mother, Jamie King.
All right, we're in recess.
So let's go back now. What's on I don't know what the exhibit number was. Did you print out anything on these phones? I think there was a printout. They objected to it.
There's multiple printouts on the phone, not all of which have been entered into evidence at this point, Your Honor.
But what's in evidence so far?
I can pull that up and take a moment.
We had, where were we at? 7 or something a little while ago?
This is in state 64.
This is the extraction.
That's correct.
Take a shot, do a squat. One or the other. Or both.
For example, 95446. Three 776 9158. There are 1,129 messages between the phone owner, Mr. Demons, and other individuals in which Mr. Francois is a participant in those conversations.
So again, you indicated this is Mr. Demon's phone. You just told me the subscriber information reflects that it's his mother's phone.
The plan is paid for by his mother. His mother's phone is in here. She is listed under Brazy, B-R-A-Z-Y, lady, and that's the 772-501-6942, which is listed as an additional number subscriber on the phone for Mr. and the phone records for T-Mobile for Mr. Dimmons.
Judge, I just want to point out, she's saying that these are messages between Mr. Demons and various people. This cell rate actually tells you, like she stated, like it's going to track, but it's coming from Young Sat Chaser Howard, and he's registering as the owner of the 9807 phone, which in these reports keep going back to Mr. Demons, but in the cell rate is showing Young Sat Chaser Howard.
And so in further showing as to who owns the phone, we can look at all of the videos and images of Mr. Demons, of which there are over 1,000 videos on the phone showing he is the user and owner of this particular device.
Judge, again, I have nothing that shows that he's the user and owner. It shows that whoever had possession of this phone took videos of Mr. Demons. They're not selfies. These are actually pictures that appears to be taken by another party.
Well, these are all videos, actually. If you want to go to the selfies, I can go to the 10,963 images to show some of those.
I don't know how she's determining your selfies, Judge, that are in testimony such.
So for example, in this particular image, it's a screenshot of a FaceTime conversation in which the large image is going to be the person who's on the other line. The local device is going to be the tiny picture up at the top, which is of Mr. Dennis. And this is just one of many, many examples.
Like, oh, you want
Go back to
selfies?
the,
Oh, you want selfies? We got selfies. 10,000 of them.
subscriber information page.
That was really funny.
In terms of this one.
So where does it show the subscriber?
This is from the device itself, Your Honor. This is an extraction from Celebrate of that phone in terms of information as to user accounts that are on this particular phone. You have YNW Melly booking at gmail.com. You have YNW Melly a Twitter account. You have YNW Melly an Instagram account. You have Melly.Montana, the Snapchat account, which the Snapchat is already in evidence, showing that one. You have Jamell Demons, Jamell.Demons, a Facebook account as well on that. In terms of the content of the messages themselves as well, show that this was Mr. Demons' phone and that he is sending out information and things personal to himself on this. So there are multiple different types of information to show you.
Judge, if I may, if we were to actually go through all of these, I've informed the court before, you're going to see messages from both of the deceased to their girlfriends, to other people. There's no question that our client had used his phone, but so did all his friends. So this is a phone that they passed amongst each other. I don't think bringing up the Celebrate or a couple of selfies proves that it was actually his phone. For that argument, there's pictures of Michael Jackson on there. So can I say that Michael Jackson is well owned his phone? Based on her argument, that's
Really?
what she's stating.
That's not at all what she's
I
saying.
don't think she
I
has
don't like
given
this
any
attorney.
definitive proof that this was 100% possessed only by Mr. Demons.
I don't like her. I think the other one's really talented. I don't like this lady.
Just picturing it obvious, I guess he shared the phone with future also.
Hey, anything else? State? No, anything else from the defense?
I would just point out that not only is that phone in Jaden King's name, so is the phone that she's trying to assign to Anthony Williams is the victim's name.
Well, I don't, the council suggested and gave me four phone numbers. One, council indicated was Mr. Demon's phone. That's the 713-9807, 772 area code. Then she had, there's one that was listed as a Christopher Thomas phone, another one as a Mr. Withers phone, and another one as Francois, also known as Track's phone. I haven't seen one as being on Mr. Williams. Am I mistaken?
Yes, Your Honor, there was one on Mr. Williams that was on the initial report. That is the 954-248-9081.
954-248.
9081.
And that's Mr. Williams, one of the students, you said
Yes.
it's his phone?
Correct, that phone, and defense counsel is well aware of the fact that the phone that Mr. Williams had at the time of his death was recovered, and a full file system extraction was done from that phone that shows it was his phone on that, and as well as the fact that the celebrate extraction that we just went through also has Mr. Williams saved under the name of Twin in the phone of Mr. Demmons, in which there's discussions back and forth that identify the 954-248-9081 phone number as that of Mr. Williams. And that there's discussions, for example, that they have gone on trips recently. They've gone to, I believe it was Detroit, and there's then again photos of Mr. Williams on the phone of Mr. Demmons in Detroit that are sent back and forth on it.
Regarding this witness, is he going to testify regarding Mr. Williams' phone?
He's going to testify to the locations of that particular cell phone,
And
yes.
they're going to be identified by phone number?
At both.
Anything else?
No.
Anything else?
Just, if you're gonna let it in for demonstrative purposes, I would say at the very least that the names are stricken from the reports and redacted, sorry. And we refer to only the phone numbers, not to the individuals.
Thank you. So we're going to bring the jury in now. As far as that demonstrative, I'm getting conflicting information. I don't want something going before the jury about this is Mr. Demon's phone or this one's phone. There's circumstantial evidence to that effect, but I'm not putting that in evidence that way. Just show the portion that shows the maps, and you can talk about the maps and the other things, but leave out the portion that has at the bottom, or I forget if it's the bottom or top, that identifies Jamell Demon's phone. Just use it by the phone number.
Use it by the phone number. Okay, that's not a problem. So I think I would need just a couple of moments to adjust that.
Go ahead.
Okay.
We're in recess.
Thank you, Judge.
Oh my gosh, are you kidding me? Oh my gosh. Another recess. Okay, so here's the thing. It's his phone, y'all. We know it's his phone. Now, they're wanting to say maybe somebody else had it that night or whatever. If they have evidence to that, I will be glad to hear it. I'll listen to what anybody has to say. Comparing him having 10,000 selfies on his phone to him having a picture of Michael Jackson on his phone. Oh, well, then it could be Michael Jackson's phone. Really, lady? I like attorneys that I'm like, even if I'm not on their side, I like to see attorneys or prosecutors or whoever that are like, doing a good job and putting up a good argument. Like the head attorney that he has, I think is fantastic. And this lady might be, but this is the first time I've heard her speak and I'm not impressed. And that could just be because there's like, they're really reaching on this one. Like they're really reaching. But this is part of, what they do. They're trying to keep this from getting into evidence because this is really, really bad for Melly if they can get it into evidence and show that he is the one who had it. Now, here's the thing. They have the video of him with a phone in his hand leaving the studio. So you can say all you want to. It's in his mama's name and it comes up as somebody else's name and that other people are using it now. Well, yeah, because he's in jail. That's not like surprising. My drillers are back. That's not surprising. But it doesn't matter who's using it now, and it doesn't matter whose name it's in, and none of that stuff matters. What matters is if he had that phone on him that night, and they can tell that kind of stuff by his phone data and compare that with the people he called and what time and the I wish when court takes recess, my construction guys upstairs would take recess. I've never seen somebody fight so much about getting the cell phone stuff in, and about how the Cellbrite data is how we know it's correct. I've never heard anybody question if Cellbrite is correct. I've heard them question other things and ask if it's as accurate as Cellbrite, but I've never heard anybody actually say, do we know if Cellbrite is accurate? They're fighting for him. I'll give them that. They're fighting for him. This argument just annoyed me because I like a good argument. I like good points. I like to hear something and be like, oh, I didn't think about that. Good point. But could it be Michael Jackson's phone is not a good point. I like to hear good arguments. But what do I know? Let's see. Yeah, Cellbrite it's the most accurate. I mean, it's in like every trial ever. Who that watches trials hasn't heard of Cellbrite? That's like, it's the accurate one that people use. I don't get it. I don't get it. Let's see. We gave you enough time. It's not our fault that there were 353 recesses today. That's true. Oh, goodness gracious. I'm trying to be as open as I can with the cell phone stuff. But 10,000 selfies, y'all. I mean, 10,000 selfies. Come on. Come on. That's his phone, y'all. But that's okay. We'll see what they say. What possible evidence could they use as direct evidence that it was his phone? Well, the 10,000 selfies is a good start. In order to take as many selfies as he did and all of the FaceTime stuff he did, that's that shows that he has possession of the phone. They had mentioned before that they have, over the course of months leading up to this, they have like dozens of times that he gave his number to people. And the number he was giving out is this number. He was logged in on that phone to all of his own personal social media stuff. So, I mean, there's a lot. Okay, look at it like this. If you have like your friend's phone, are you going to have, scratch that. If it's anybody, do you have any friends that, or family members or anything that have 10,000 selfies of you on their phone and are logged into every single one of your social media things and are giving out that phone number and saying it's, your phone number? It's just, I mean, it's his phone, y'all. Look, they could prove me wrong otherwise. As of right now, come on, y'all. But we'll see if they have any evidence as to who had it that night. If somebody else different had it, they say they have evidence. So I have an open mind. There's absolutely no chance of that. Oh, and that was a big thing too. They were like, well, Mr. Francois is the one who gave it to us, but they have a recorded jail call where Melly was on the recorded line giving Francois track, 100K track, whatever. Each of these people have 27 different things that they go by, people in the entertainment world. So I have to make sure I give all the names, government names, stage names, nicknames. But they have a recorded jail call of him giving him the passcode so that he could get into the phone. It's his phone, y'all. Let's see. Look, I have, you know how you're going to know it's my phone? There are pictures of Lucy. There are probably the only thing on my phone is pictures of the sunset, screenshots of either funny memes or articles from trials and stuff I want to read, and Lucy, and that's it. Mostly Lucy. Lucy can she'll be sleeping and it'll be the same. I'll have this 100 of the same picture on there already, and I'll be like, oh my gosh, it's the cutest little sleep ever. And then she'll move like this. I'm like, oh my gosh, let's get the camera back out again. I'm all for having an open mind as long as your brain doesn't fall out. Yes. I will keep an open mind. And there have been things that I've said before that I'm that I believed, and then things have changed my mind. So I will always have an open mind. But I will also always have common sense. Let's see. How can they say it's the same phone that's in his hand? That's what I'm saying. I want to hear the evidence of that. Now, the phone that he had in his hand when he got in the car, if they're saying that it was somebody else that had it, I'm curious. I mean, I want to see. There's only 4 of them that got in that car, and 3 of them showed up at the hospital, and 1 of them was gone. So if he separated from them before this happened, then that doesn't fit with the evidence right now. It doesn't fit with the timeline. So I want to hear how that's a possibility, how it happened. Because right now it doesn't fit, but we don't have all the pieces yet. So I want to hear how they make sense of it. Let's see. I get your point of view is about it being his phone. The problem is the prosecutor has not properly established it. My group of friends, we all have each other's passcode. Makes no. I would not. My friends do not have my passcode. Nope. Some people do. I have one friend that has my passcode, and if anything ever happens to me, she has strict instructions to get my phone. And I don't have the passcodes of any of my friends. I mean, some people might do that. I don't. I wouldn't. I don't have enough trust for that. Would a reasonable person believe that it's not his phone? Well, I mean, do you think it's reasonable? Like, try to look at it from if we hadn't heard everything else, you know? Think about if we hadn't heard everything else, if there was somebody who told you, this isn't my phone, it's somebody else's phone, but there's 10,000 selfies of me on it, and it's logged into all of my social media, and I give out this phone number, but it's not my phone. Does that sound reasonable? To me, it doesn't, but what do I know? Let's see. I have zero offense with my passcode. I have one, but she is also, she's a police officer here. So I'm like, if I'm going to give it to one, it's going to be the one who might be investigating what happens to me anyway. So she can have it. Let's see. I have my mom's. I do have my mom's. She ain't got mine though. But I do have my mom's passcode. Let's see. Oh, fingerprint on the phone. That's a good point, Virginia. They said something about verifying that it's his phone with the fingerprint analysis stuff. So when did the Face ID come out? What year was that? I'm going to Google it. Dang, my keyboard's doing the sticky thing again. I thought the batteries fixed it. I'm going to have to figure that out. That drives me nuts.
Sure, makes sense. Thank you.
Bring it back.
Back.
Jury's coming in.
They're going to bring him back just to let him go. So the facial ID came out in 2017, and this happened in
Very
2018. So it could have been the fingerprint thing too. When she said fingerprint recognition, I thought about that. If that's maybe, I don't know if they can even do that. They can check the fingerprint that you have to use to open your phone.
Ms. Jones, thank you.
Reset button. We'll look for reset
Please
button.
be seated. Let the record once again reflect the presence of our jury, as well as the defendant, the defendants, his counsel, the assistant attorney, all which remains unstated. Ms. Jones, I apologize, but I need to resolve certain issues before we go further. It's approaching 5 o'clock now, so my thought is I'm going to resolve it. We'll see you all back tomorrow morning. So remember the admonition: do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research about the case. All right? You hear that every time we break. I tell you that, and it's very important. So, ladies and gentlemen, I'm sorry for the inconvenience. We'll see you back tomorrow at 9. Thank you.
I'm pissed. all this whole day for that. Seriously? I could have been at the beach, y'all. It's okay. I got to hang out with y'all. What?
Thank you. Let the record reflect that you're stepped down. Anything further to discuss, counsel?
I don't believe so.
Sure, I will, if I can make the witness aware, especially Judge Collins, because you were on the stand in the middle of your testimony, I can't have any communication with you outside the presence of defense counsel. If there's any emergencies or anything else, please contact my office so they can get a message to me so that there's always a record of that.
Understood.
Thank you.
All right. Thank you all. Appreciate it.
Thank you, Your Honor.
We're adjourned.
Thank you, Danny.
I'm so mad. What? Y'all. I woke up at 5:30 for this. Oh my gosh. Oh well, it's Taco Tuesday. I'm about to call my friends and go celebrate. Take a shot, do a squat. What kind of day was this? This is crazy. So this was the most explosive day. Insanity. Ridiculous. The only one who should be mad is the juror who was in the ER. Could you imagine rushing through, like, having to go, like, being so sick and going and then sitting through this all day? No, me neither. What time is it? 3:40 my time. All right. I'm not going to stay on here long. It's not even like we have a whole lot to recap. Like, we've spent the majority of our day chit-chatting and hanging out. Y'all hear that? They're getting loud up there. Chit-chatting and hanging out. We don't even have anything. Like, normally at the end of the day, like, I'll go through and, like, answer some questions and we'll talk about everything we just heard and try to make sense of it. And there's nothing to make sense of, and there's nothing to talk about because we've talked all day, because all we've done all day is recess and hang out. But at least we had good company. We got to hang out. So, Nan, you just woke up from your nap. You missed everything. I am in Florida, but I am in the Panhandle, so I am Central Time Zone. The whole rest of Florida is Eastern, but the Panhandle, we are Central. So it's an hour earlier here. Bye, Ricky Watson. Enjoy your evening. Kayla says, we have nothing. We got nada. All right, y'all. Well, I appreciate How many sidebars tomorrow? I tell you what, when we start tomorrow morning, I'll do a poll, and we'll guess. We'll start it. I guess like the first option, like the lowest option would need to be between like 0 and 3, and the next one would be between like 4 and 7 or something like that. And we'll see how many. What a day. What a day. All right, y'all. Well, I'm going to go enjoy my evening because final count. Oh, look at this. Final count. 8, 10, 7, and recess. So many recesses. Let's see. What time is it for UK tomorrow? I have no idea. It's 9 a.m. Eastern. So I have no idea. It's 9 a.m. Eastern. So I'll be on here about 15 minutes beforehand. 10, 15 minutes, something like that. Alrighty. All right, y'all. I appreciate everything. Thank you for the super chats. Thank you for hanging out with me. If you could please just like our little video here. If you haven't subscribed yet, go ahead and subscribe. And if you want to turn on notifications, then you'll get a notification as soon as we go live. That way you don't miss anything. I'm gonna go back out to the beach, actually. I think I'm gonna go back out to the beach and then go enjoy Taco Tuesday. So y'all enjoy the rest of your evening, and maybe tomorrow will be a little bit more there will be a little bit more to actually watch and talk about and digest, and it won't be just a day full of recess. So I appreciate y'all. Don't forget to like the video, and I appreciate y'all. Thank you for reporting to jury duty, and I will see you tomorrow.